International Disputes Week webinar on the arbitration of international trust disputes hosted by Fox Williams, Macfarlanes and Withers. I'm John Bender, the moderator for this hour-long event. As Director of Trust Protector Services at Bender Brothers & Co., an Anglo-Swiss family office, I'm only too well aware that internal conflicts can arise amongst those party to a fiduciary settlement. Under such circumstances, it is important that differences are resolved swiftly, affordably, and discreetly. Unfortunately, litigation often leads to a protracted, costly, and somewhat public outcome. An emerging global trend in the world of dynastic trusts has been the use of arbitration as an alternative to the courts, an approach which has been well known for commercial trust disputes. Without doubt, ADR in such a context can be more confidential, versatile, and possibly faster than litigation. We're very fortunate to have 5 highly expert panelists for today's discussion. David Butler, a partner at Fox Williams, is a fraud lawyer and commercial litigator who handles commercial disputes in both court and arbitration settings. Before he joined Fox Williams in 2017, David worked in the Cayman Islands, first with Appleby, and then as partner and co-head of Harney's litigation and insolvency practice on the island. David's practice in Cayman included litigating a number of trust disputes, representing both trustee and beneficiary parties in proceedings in the Grand Court. Charles Lloyd has been a partner at Macfarlanes since 2001 and is head of the Trust and Probate Litigation Group. He has particular experience in contentious trust and probate work, in addition to international commercial litigation, including fraud and asset tracing. Charles acted for a Russian family in obtaining a worldwide freezing order for a £500 million trust dispute in numerous jurisdictions. He has also advised Saudi families with respect to probate fraud, succession, and conflict of laws, which can be quite a challenge within a Sharia context. Charles was called to the bar in 1988 and qualified as a solicitor in 1992. Dancia Penn OBE QC is an arbitrator and mediator at 33 Bedford Row, as well as at Caribbean Arbitrators. She is on the Eastern Caribbean Supreme Court roster of mediators and a judge of the Caribbean Community Administrative Tribunal. As head of chambers at Dancia Penn Co., she has appeared in the courts at all levels, including the Privy Council. Between 1992 and 1999, Dancia served as Attorney General of the Virgin Islands and was appointed Queen's Counsel in 1996. Between 2004 and 2007, she served as Deputy Governor of the Virgin Islands, the highest civic post that can be held by a Virgin Islander. Between 2007 and 2011, Dancia served as a member of the First House of Assembly of the Virgin Islands. In 1981, she was admitted to practice as a barrister and solicitor of the Eastern Caribbean Supreme Court in the Virgin Islands, as well as in Barbados in 1999. The Honourable Barry Leon, a Canadian, is an arbitrator and mediator at 33 Bedford Row, Arbitration Place, and Caribbean Arbitrators. He was a judge of the BVI Commercial Court between 2015 and 2018. Prior to this appointment, Barry chaired the Arbitration Committee of the ICC Canada to the Canadian Chamber of Commerce. Between 2009 and 2015, he was partner and head of the International Arbitration Group at Purley Robertson, Hill and McDougall. He had been a partner with Tories until 2009 in his litigation and dispute resolution practice in Toronto. Dawn Goodman is Senior Counsel at Withers in the Trust, Estate and Inheritance Disputes team. She's had international experience litigating in different jurisdictions, such as Bermuda, the Bahamas, and the BVI. In particular, she has specialized in conflict of laws cases involving jurisdictions such as Italy, Jersey, Guernsey, and the Cayman Islands. Having previously been a divorce lawyer, Dawn is able to bring a unique perspective on the effects matrimonial conflicts can have on trust disputes. She is also an experienced mediator and is accredited by the Centre for Effective Dispute Resolution. She was called to the bar in England and Wales in 1980, the BVI in 2008, and was granted the Irish Practicing Certificate in 2019. Before we begin, I would like to remind everyone that this session is being recorded. Were there a desire to ask a question anonymously, please request that your name be withheld through the Q&A function. Without further ado, I would like to turn to David Butler and Charles Lloyd for their thoughts on the general merits of trust arbitration, which will be followed by more specific commentary on the Caribbean and other Commonwealth jurisdictions from our three other panelists. David, you have the floor.
Thank you, John. I thought it would be helpful to start off by identifying some benefits of using arbitral tribunals instead of the courts to resolve trust disputes, and then to set the scene with some general background and context about arbitrating trust disputes. We probably ought to define at the outset what we actually mean by a trust dispute in this context. And what we mean when we talk about trust disputes is a dispute or difference that arises between a trustee and a beneficiary, between co-trustees, between former trustees and their successors, between trustee and protector, or between beneficiaries. We're not talking about disputes between trustees and third parties, say an accountant or a service provider, arising out of some allegedly negligent performance by that service provider. So looking at these, for want of a better term, internal disputes, arbitration offers at least 4 benefits over the resolution of such disputes in the courts, as I see it. The first and most obvious benefit, as John has already touched on, is confidentiality. The core feature of arbitration is that it's a means of dispute resolution that's conducted in private, and the dispute remains confidential between the parties. In an age where concerns about open justice are becoming increasingly important, at least to the judiciary in England, and it's becoming more difficult to persuade judges to hear applications or conduct trials in private, even when the subject matter is sensitive, a means of dispute resolution that is confidential by default is attractive to settlers and beneficiaries alike. Secondly, the relative speed of resolving a dispute by arbitration. When I checked yesterday, the listing team in the Chancery Division in the High Court here told me that the earliest slot for a 1-week trial in the Chancery Division was May 2022, and for a 2-week trial, October 2022. Bearing in mind that it can take some time, a year or more perhaps, to get to the point where the court actually directs the parties list a trust dispute for trial, it could be somewhere between 2 and 3 or more years before a dispute is resolved in a courtroom. And I feel relatively confident in saying that a timetable of that sort is probably also what parties might expect to see in the Channel Islands or the Caribbean jurisdictions. The arbitration process, by contrast, can move along much more swiftly than this, depending on, obviously, the number and choice of arbitrators. Third is the option to prevent unnecessary appeals. Many jurisdictions still provide for appeals as of right from first instance court decisions, and for further appeals as of right from those appeals. All that additional unnecessary cost and litigation can be saved by selecting the right seat and venue for an arbitration. Fourth, arbitration offers flexibility in terms of where and how a dispute is resolved. Many trusts these days are settled in jurisdictions that are a long way from where the settlers and beneficiaries actually reside. There is a benefit to beneficiaries in having trust disputes resolved in tribunals that are closer to home geographically and perhaps culturally too. I wanted just to spend a couple of minutes discussing the juridical basis for arbitrating trust disputes. A trust is, of course, not a contract, and a trust instrument will often make provision for or confer discretionary entitlements upon people that don't have capacity to enter into a contract, or people that don't even exist yet. So how does one validly incorporate an arbitration agreement into a trust? Some have posited and I probably do their argument an injustice by abridging it this severely, that one should regard a modern trust as a quasi-contract between settler and trustee. Using that analysis, one can then rely on section 82(2) of the Arbitration Act, which broadens the concept of the parties to an arbitration agreement to include any person claiming under or through a party to the agreement, to include beneficiaries as parties claiming under the settler. I'm not aware that the point has been taken in any case, and the Trust Law Committee has rejected it in favour of specific legislation governing the use of arbitration clauses in settlements. Legislation has been adopted in a number of jurisdictions, including the Bahamas, Guernsey, Malta, Switzerland, and most recently New Zealand, as well as in some states of the US. The legislation adopted in these jurisdictions differs in its scope. Dawn will be touching upon some of these later, I understand, but I will mention briefly here the Bahamas legislation, as this is widely credited as being the most comprehensive. The trust arbitration provisions were enacted as sections 91A to C and Schedule 2 of the Bahamas Trustee Amendment Act 2012. And briefly, what those sections do are to deem a clause requiring the parties in relation to a trust to refer to a dispute to arbitration, an arbitration agreement by and between those parties, and to apply the Bahamas Arbitration Act to a trust arbitration. Section 91B then gives the tribunal, in addition to its powers qua tribunal, all the powers of the court in relation to the administration, execution or variation of the trust, or the exercise of any power arising under the trust, including the power to appoint representatives to represent the interest of a class. Section 91C defines what an administration question is in broad terms, and includes nearly all types of difference that might arise as between trustees and beneficiaries, and between beneficiaries that could have been resolved in the Bahamas court. One significant group of exclusions from the scope of what is arbitrable under the Bahamas legislation are claims about the validity of the trust itself, the validity of dispositions, and proprietary claims against trust assets. Indeed, it's a common feature of the legislation adopted thus far that claims of this sort are excluded from the scope of the disputes that can be resolved by arbitration. I hope that sets the scene, and I shall now pass the baton to Charles.
Thanks very much, David. Thank you, David. Thank you, John. John, please stop me if I go on a bit. It's an interesting subject, and I've got lots of things to say. I think perhaps one of the first things is it's surprising that as an English lawyer, we aren't, and English lawyers generally, we aren't embracing this idea of arbitration of trust disputes in a much greater way than perhaps we are at the moment. I mean, so much of the trust litigation goes on in offshore jurisdictions at the moment. And if there were a working arbitration model in England, a lot of that work could possibly be going on here, which would advantage the English lawyers. But we're a conservative bunch, and we like the status quo. But let me just, as a trust litigator, mention some of the difficulties that I see. I mean, on the one hand, as David says, clients would love arbitration. It's confidential. They love the idea of it speeding up the process and being entirely private. But as a trust litigator, there are all sorts of things that worry us about arbitrating trust disputes. And I don't want to be characterized as the person throwing the marbles under the horse's hooves, but here goes. I am going to spend 5 minutes just mentioning some of the difficulties that I can see. As David mentioned, a trust deed or a will is obviously not a contract. And that gives rise to the primary problem for trust arbitration in terms of arbitration clauses, because the rights and entitlements conferred on beneficiaries are conferred as bounty for those beneficiaries, and there's no contract. And that means that the usual analysis of an arbitration agreement in writing, some kind of contractual arrangement, just doesn't apply. So it's a round peg in a square hole when we come to look at that aspect of using arbitration clauses. The second point, or problem, is that trust disputes cover a really wide variety of disputes in character and in nature. There are what is termed the external disputes, the rocket launcher disputes, where there are challenges to the actual validity of the will or the trust or the settlement, possibly being challenged on the basis that it's been procured by undue influence or lack of capacity, standard tools in the toolbox of the chancery lawyer. Or it may be that the transfers of the property into the trust themselves are being challenged, and they would be challenged on the basis of forced heirship regimes, succession rights, community of property regimes. And those external type claims, the rocket launcher type claims, are really just not appropriate for arbitration. And I think that a lot of jurisdictions where legislation has been introduced have acknowledged that those types of claims fall outside even the arbitration legislation. But then if you turn to the internal disputes within a trust, you have the removal of protectors, removal of trustees, breach of trust claims, disputes between beneficiaries, construction summonses, rectification, rescission, blessing applications for decisions of the trustees, directions applications, Beddoes applications, all these things which are really part of the supervisory jurisdiction of the court, which allows the court to administer and assist trustees and beneficiaries to ensure that the trust is properly administered. And there is a view amongst lawyers and judges that that ability to go to the court is part of an irreducible core of rights that a beneficiary has. And Smelly J in the Cayman Islands said in Aon and Barclays, there is no justification for a complete prohibition against access to the courts. So that's another problem. The third point I wanted to raise is obviously the difficulty of binding beneficiaries, and this is tied in with the fact that they aren't party to a contract, and in many cases they will be lacking capacity because they are minors or as yet unborn. And there are plenty of difficulties with that. English law says that arbitration clauses don't actually work. I think it's been tried to argue that they're very similar to exclusive jurisdiction clauses, which have carry a certain amount of weight, but they probably just don't work. In the US, condition precedents are used to make the beneficiaries bound to the arbitration clause by saying that if they want to get any benefit, they have to acknowledge and agree to the arbitration clause, or slightly more draconianly, a forfeiture clause can be used to say that they will forfeit their interest if they don't agree to the clause itself. And then, having bound the beneficiaries, you've then got a problem of how they're going to be represented. Is it right that they should be represented by a mechanism installed in the trust deed itself by the testator or the settlor of the trust or the will? Because is that right that they should be nominating the person to represent those parties? It's quite troubling in a way that someone other than a court should really be deciding on the representation of those parties' interests. So there is, of course, always the local court at the seat of the arbitration, which may be able to assist in appointing representatives. And then the fifth problem is Article 6 of the European Court of Human Rights, which is all about a fair hearing and a public hearing and an independent and impartial hearing and natural justice. Clearly, the adult beneficiaries of the trust can agree to waive their rights under that article, but the minors and unborns just don't have capacity to be able to do that. So that is another close to insurmountable problem. I know that the English Trust Law Committee looked at this, and I think they came up with some very clever ways to get around it. And I understand there was an opinion from leading counsel, may even have been David Bramble, I don't know, who decided that you could get around these difficulties, but they still remain fairly significant problems. Enforceability, obviously that's another issue that goes hand in glove with whether or not the parties have been properly bound and properly represented. And finally, I just wanted to mention the position of the tax collectors, who are not going to be party to these arbitration clauses or arrangements, but clearly have a very substantial interest in the outcome of the proceedings. And you could say that it's no different in an arbitration to in the court process, because they're third parties in the court process, but of course they're always notified in a court process, and they could be notified in an arbitration. But whether or not HMRC, for example, will be happy with an arbitrator selected by the parties determining the rights of the beneficiaries and the trusts and the validity of instruments which could have a significant impact on tax, whether they'll be happy with that, I'm not sure. So my conclusion is really that it doesn't work unless there is primary legislation which effectively gives the arbitrator the full powers of a High Court judge to deal with all the supervisory jurisdictional elements of administering a trust. Because I think what the important point to bear in mind is that a lot of the disputes that we get involved in can involve multiple different claims. I mean, within one dispute, you could have a Beddoes application, you could have a removal application, you could have construction summons, you could have all sorts of different breaches of trust alleged, and that's just all part of one dispute. And you really want to be in front of one arbitrator in one forum to deal with all of that at once if it's going to be truly cost effective and efficient. I think that was my main point, actually. Thank you, John.
Charles, thank you very much, and David, thank you as well. I think that sets the scene very suitably. There have been some very innovative legislative reforms in the Caribbean, notably the Bahamas, as David has pointed out. Dancia, Penn, and Barry Leon are well placed to give us an insight with decades of experience on the bench in the region. Dancia, would you like to start off?
Thank you very much, John. I certainly am very happy to do so, and I'm very delighted to take part in this very important discussion on trusts arbitration. Our focus will be on, as you have said, developments on trust arbitration in the Caribbean. And I think it is right that I point out that the Caribbean is a very diverse region, diverse in languages, diverse in legal systems. We have French-speaking islands, we have Dutch-speaking, we have Spanish-speaking, and of course, English-speaking. Some jurisdictions are common law, some are Roman Dutch, some are common law. The civil law as well. I think I confused what I was saying there. But the point is that our focus in this very brief presentation is on the English-speaking Caribbean, some English-speaking Caribbean jurisdictions, all of which have a common law legal system. There are, of course, jurisdictions which are often referred to as offshore jurisdictions. That's our focus. Of course, as has been said, trusts are becoming increasingly popular and increasingly used in these jurisdictions as a means of structuring wealth, both for testamentary and succession purposes, as well, of course, for commercial purposes. The jurisdictions are primarily ones in which the courts are trusts and arbitration friendly. The New York Convention on the Enforcement of Arbitral Awards generally applies. The UN Convention on Human Rights applies. The jurisdictions also have written constitutions with enshrined human rights provisions and provisions in the constitutions to enforce those rights. I will do a very quick excursion through just a few of those jurisdictions, beginning with the British Virgin Islands, the BVI, where I am from, where I live, where I work, and where I have for a great part of my life been involved in the policy formulation, the drafting, the enactment, and the implementation of some of the laws which inform this area. I also, of course, as you've said, John, currently work as an arbitrator and as counsel and a mediator. The news from BVI is this. On the 22nd of April, just a few weeks ago, our House of Assembly passed a major amendment reforming our trustee legislation. The bill was assented to by the governor on the 7th of May, and it will come into force on a date to be proclaimed by the governor in the Gazette. I will not take time in my brief 5 minutes to go into the provisions of that new amendment, but they are important and they are, as I have said, modern reforms. However, the introduction of trusts arbitration is not part of those recent amendments. There is a committee, it's a committee of the BVI arbitration group, which is working actively on making recommendations for trusts arbitration in the British Virgin Islands and its introduction. No doubt, some of the considerations that the committee is having, many alluded to by Charles in particular just now in his presentation. No doubt among those considerations are public policy issues, the issue of the courts and whether the legislation may oust the jurisdiction of the courts, considerations of open justice, access to justice and natural justice. We have the UN Convention on Human Rights, which gives a right to a hearing which is fair, held in public, takes place within a reasonable time, and is conducted by an independent and impartial tribunal established by law. Of course, as we know, the hallmarks of arbitration, or among the hallmarks of arbitration, confidentiality and a tribunal chosen by the parties. So I think issues like that are and will remain very important. And as I have said, they're being, I believe, given very active consideration by the committee that is working on recommendations for the introduction of trusts arbitration legislation in BVI. Very quickly to move to the Cayman Islands. As elsewhere, the Cayman Islands is seeing a growth in the use of trusts and trust arbitration. By the Cayman Islands Amendment Act, I think it's section 21F of the Cayman Islands Trust Amendment Act, there is a provision for the resolution of trust disputes by arbitration. I will not take time to read it, but it is a very simple and clearly written provision, which essentially says that among other remedies which may be employed if there is a trust dispute is recourse to arbitration. As far as I have been able to ascertain, however, there have really not been any major trust arbitrations taking place in the Cayman Islands, nor has there been much litigation. Charles just mentioned the important case of AN against Barclays Bank trustees, where yes, the Chief Justice Anthony Smelly was very clear in his decision that it is important not to, in effect, employ mechanisms that could deprive parties of access to the courts. There is then the Commonwealth of the Bahamas, which is regarded, as has been said and is well known, as the Caribbean offshore jurisdiction, which has the most progressive and important trust legislation. Others will speak to that, but I will just for myself make two very brief observations in relation to the Bahamas Act. One is that unlike the Cayman Islands legislation, for example, it provides for recourse to trust arbitration of any dispute or an administrative question arising between parties in relation to the trusts. The Cayman Islands formulation is far narrower and less expensive. Based on views as have been expressed as well to some of whom I have spoken on the ground in the Bahamas, it does not appear that as of now, there has been any big uptick in the use of trust arbitration legislation in the Bahamas. There are reasons which are cited for that, and I'm sure we will be discussing some of those later in this discussion this morning, or this afternoon for some of you. But it does appear, and I've been told, that what happens is that although the Bahamas legislation is used and more the clauses are being put in trust agreements, the seat is not, the Bahamas is not being chosen as the seat of the arbitrations. London remains the preferred seat. There are other issues, as I have said, but I believe, John, that I have exhausted my 5 minutes, and I close here and look forward to our continuing discussion. Thank you.
Dancia, thank you for that. Barry, also from the BVI, further comments? Oh, you're on mute.
Sorry about that. There's 5 things I wanted to cover, John, regarding trust arbitration in the Bahamas, and that's going to be my focus. And you've had a preview of it already in the remarks by David and by Dancia. So the Bahamas Trustee Amendment Act of 2011 introduced the possibility of resolving trust disputes through arbitration. And Section 91A enables any dispute or administration question in relation to a trust to be determined by arbitration. What is interesting is it sets, and it's, I think, a well-drafted piece of legislation in terms of conveying clearly what is the aim is. It provides the object of this section is to enable any dispute or administration question in relation to a trust to be determined by arbitration in accordance with the provisions of the trust instruments. And then it goes on to deal specifically with some specifics and with the powers of the arbitral tribunal, which I won't read. The ability that it confers is that settlers can impose mandatory arbitration on internal trust disputes. And it empowers the tribunals, among other things, to appoint representatives of those who can't represent themselves, minors and incapacitated and unborn. There were 5 aims that David Brownveld, QC, and who we'll be hearing from later, set out in a paper that he wrote. And I'm going to read through those 5 points and then talk about them just briefly. Usurping the role of the court, binding all parties, representation of minors and unascertained, empowering the arbitral tribunal to make the necessary awards, and ensuring enforceability of the arbitral award. What it doesn't seek to cover is the problematic functions that Charles Lloyd outlined earlier, the rocket launcher claims, the supervisory matters, and so on. As Charles noted, and Dancia noted, as a matter of public policy, turning those functions over to arbitration may not be appropriate, even if legislatures may do so as under their constitutional powers. Turning to enforceability, the enforceability of awards, which was the 5th point that I listed earlier, is certainly not a problem within the Bahamas as long as there's assets there. An open question is whether it's been achieved internationally under the New York Convention. And that really goes back to the question of whether other jurisdictions would recognize from a public policy point of view that these are arbitrable matters that those jurisdictions should enforce. There has been some litigation in the Bahamas, but very little dealing with the legislation. And in short, the one case that really dealt with it essentially said the act means what it says, and held that those kinds of disputes could be arbitrated. That's in a case of Volpe, and there's a few Volpe pieces of litigation, but this was a 2018 decision. Sticking with the Bahamas for a second, and just to see where its legislation is going, the Bahamas is about to introduce the model law, and it essentially will be the model law with one innovation that is only been used in one other place, and that's Mauritius, which is to have the Permanent Court of Arbitration take on the functions of the court, with the exception of setting aside and enforcing awards. The idea there is to bring to the arbitration in the Bahamas an international standard and international expertise, which courts in most jurisdictions don't have. But having said that, the Bahamian courts are supportive of arbitration, both in their judicial decisions and in their administration and training. The Chief Justice is supportive of the use of arbitration and ADR and of modernizing the legislation, and that's occurring almost as we speak. All of the judges of Bahamas received education, judicial education on arbitration and ADR this past summer, including with people instructing from the Permanent Court of Arbitration and UNCITRAL and ICSID and so forth. And the Chief Justice is working on bringing a modern civil procedure rules to the Bahamas. So from that perspective, Bahamas is in good shape. Another piece of litigation dealing with arbitration in the Bahamas and also involving that same the same party as Volpe determined that the Bahamian courts can't assist under the current rules in the Bahamas, can't assist disputes that are occurring elsewhere where there's no connection to the Bahamas. And this is really just basic civil procedure that would apply under the civil procedure rules in the Bahamas, not particular to trust arbitration or trust disputes, but of course, where you have a situation where there's no connection to the Bahamas in terms of parties and assets and so forth, makes problematic the court assistance. The last matter that I was going to talk about briefly, and Dancia mentioned it, is that there hasn't been a lot of take-up. And the reason for that, I think, is that the benefits that David Butler, and Dancia and I spoke with a number of people involved in trust disputes in the Bahamas. The factors that David mentioned are achievable in the courts. There's knowledgeable and experienced judges when it comes to trust matters. They're heard reasonably expeditiously, and through informal means, they can be heard essentially privately and confidentially. So those needs don't seem to exist. Also, there's the factor that there isn't the same use of arbitration generally in the Bahamas and generally in the Caribbean, as you would see in London. It's coming and it's developing, but it's not there yet. So I think there's a natural hesitancy. Just to add one final point, and that is the level of confidentiality in the courts isn't assured in the Bahamas when it comes to arbitration. It is more assured in BVI under the provisions of its statute, which provide for a high level of confidentiality for arbitration matters in court. John, back to you.
Okay, thank you, Barry and Dancia. The Caribbean jurisdictions have been notably innovative in drafting trust legislation, but they have not been the only ones. Don Goodman has kindly agreed to discuss what has been underway elsewhere in the Commonwealth. Don, you have the floor.
Thank you very much. I should warn you that I have a very poor internet today due to a storm, so I may have to switch off the video if it becomes too difficult. It was very useful to hear your analysis, Dancia and Barry, of the situation in the Caribbean. I'm just going to look at a few of the other jurisdictions which have introduced arbitration as a way forward in trust matters, and then look at what might be adopted from some of those jurisdictions and those in the Caribbean if and when the England and Wales brings in its own legislation on this subject, which I think all of us operating in the English sphere hope will be sooner rather than later, for the reasons that David mentioned right at the beginning. primarily ease of access to justice. Nobody doubts the quality of justice once you get there, but it can take a very long time at the moment, and unfortunately that has not been assisted by the backlog that has been occasioned during the COVID crisis. And also the emphasis on open justice is very, very strong in England and Wales, and there are some sensitive family matters where, in a trust context, where one would really rather that they weren't going to be in a public forum. So let's hope that that happens. But I just wanted to start off by saying that, of course, arbitration as between trustees and third parties, provided it doesn't affect the validity of the structure, has long been available. And indeed, we've been involved in some ourselves. We've done title disputes through arbitration, where one party has been a trustee. And trustees may well find themselves litigating, or rather arbitrating, over a contract where there is an arbitral clause. So that context seems to me to be fairly well addressed outside the need for provisions relating to arbitration of trusts. It's when you get to internal matters that you hit difficulties, or external matters where there's an attack on the trust, which may also affect those under it, and particularly those who can't represent themselves, that one has the problem. So we've seen how, or we've heard how the Bahamas has dealt with it. So I thought we'd look at what's happening in the Channel Islands. Well, the first point is that Jersey has taken a look at this recently and decided not to pursue it at any rate at the moment. So it was considered when Jersey was looking at the 7th Amendment to the Trust Jersey law, but it was felt that sensitive cases could be heard in private and so on, and that there was no real pressing need for it at the moment. Guernsey, on the other hand, introduced its section 63 to the Trust's Guernsey law, but really it's within a fairly narrow compass. It relates to breach of trust actions, and that seems to be defined quite narrowly to relate to trustees, not other fiduciaries. And of course, it's carefully done with reference to the court's involvement in relation to minors, unborns, and those who cannot be ascertained. Malta is an interesting one because, of course, Malta is really a civil code jurisdiction, and it has entrenched heirship laws, for example. But it does have a trust law, which takes largely from other jurisdictions' law. And Section 15A of the Maltese Arbitration Act enables the settlor to insert an arbitration clause in the trust deed. And that clause is stated expressly to be binding on trustees, protectors, and beneficiaries in relation to matters arising under or in the trust. And there are similar provisions for wills and foundations, which I think is quite an interesting add-on. What is interesting is the treatment of internal trust issues. And what it says is, provision for the trustees to seek directions under the Trusts and Trustees Act. And then it says unless, and the unless is if the matter becomes contentious, in which case it's arbitrated. I think that's quite interesting. So the court can deal with stuff that isn't contentious. Anything that is contentious goes to arbitration. New Zealand is perhaps the most recent. This is the Trusts Act 2019, which in fact only came into force at the beginning of this year. And it's sections 142 to 148, which make provision for arbitration. They apply to internal matters. So for example, they don't cover a challenge on the basis of validity. Essentially, they're directed at disputes between trustees and beneficiaries, and it doesn't provide for disputes between beneficiaries and other power holders. The important point to note, in contrast with the position, say, in the Bahamas, is that the representatives for minors, unborns, others lacking capacity must, absolutely must, be appointed by the court, and any awards involving representatives for unborns, minors, incapacitated other persons have to be approved by the court. So with that range of options open to them to consider, and recognising that we really ought to have arbitration for trusts in the smorgasbord of available remedies to us here in England and Wales, there does seem to be a particular uptick in interest of getting the legislation on this subject over the line. But equally, it's recognised by STEP, for example, their technical committee, and I think by the Law Commission, that the Arbitration Act 1996 simply doesn't get us there. The ICC had a working party which included David Bramble of QC, the architect really of the most innovative of the legislation, that in the Bahamas, to look into this. And at the end of 2018, they launched a model clause, and it says, any beneficiary claiming or accepting any benefit, interest, or right under the trust shall be bound by and shall be deemed to have agreed to the provision of this arbitration clause. Now, I'm sure that that will become the subject of discussion later on in this session, but the deeming bit is really interesting. And the big question is, does it or does it not work when it comes to enforcement under the New York Convention? As Barry said, you know, it works in a local jurisdiction. Whether it works internationally is something that perhaps needs to be tested. The Law Commission's 14th programme of law reform topics, which came out in March this year, included amongst its number of top subjects to be dealt with, a review of the Arbitration Act, including trust arbitration. So we anticipate it's going to happen. It's just a question of when. And I think it's probably fair to say that the government has got a lot on its plate at the moment, so this may get pushed down the line just a little. So I'm going to look into the crystal ball and ask the question, what might it look like if and when it does come through? Well, STEP have recommended that it shouldn't apply to validity disputes. That seems to be a generally held view, so I suspect it won't apply to the major set piece litigation that we see where the trust is under attack. So will it just apply to internal disputes of the breach of trust or breach of fiduciary duty kind, probably involving all sorts of power holders as well as trustees? But bear in mind, we don't see so many different types of power holders in England as we tend to in the offshore world. Or will it apply wider to the sort of relief that you could get if you were applying to the court in its supervisory jurisdiction for its assistance? Variation, blessing, better applications, and construction, rectification, and so on. Well, we don't really know. My best guess is that it won't deal with mistake because of the difficulty that I think it was Charles alluded to earlier about the involvement of HMRC. Will it deal with blessing applications? Simply don't know. We'll have to wait and see. Will it go the Bahamas route of permitting the settlor to provide the mechanism for choosing the representative for those lacking capacity or unborns, or will it leave it to the tribunal to decide? I think it's most unlikely that the court will give up that essential part of its armoury to protect those who can't protect themselves. So I think it will probably follow the Guernsey or New Zealand model here. And of course, it will also need to consider human rights and enforcement issues, such as raised by Charles. It's quite a tall order, so we'll just have to wait and see. But hopefully, whatever they decide.
Dawn, thank you very much. Now that we've heard from our 5 panelists, we can move on to more general discussion. David Bramble, QC, has kindly agreed to pick up on a few points raised earlier to get the Q&A session underway. As many of you are aware, David has specialized in international trust and fiduciary litigation, having been called to the bar of the Eastern Caribbean Supreme Court in addition to England and Wales. He played a pivotal role in drafting the Bahamas Trustee Amendment Act 2011, which I think all the previous panelists have made reference, particularly the provisions providing for mandatory arbitration of trust disputes with regard to beneficiaries lacking capacity, such as minors and those yet to be born or ascertained. David, is there anything you would like to raise in response to the insights we've just heard this afternoon?
I believe, well, good afternoon, everybody, to start with. I believe you pointed out two issues that both, I think, Dawn and Charles in particular had raised. And one of them is the Volpe decision that's already been mentioned. There was a decision, there have been several, I think, as we've been told, but there was one in August of 2019 in which the court, I think Barry has mentioned this, the court refused an injunction. Now, an injunction was sought by the claimant in that case. It's not too clear from the judgment against whom it was sought. You must assume it's the defendants. They were trying to avoid jurisdiction. I must assume it's also in relation to the subject matter of the arbitration that Barry's explained to us. But it was refused on two grounds. One was that the injunction was in support of foreign proceedings, and it fell foul of the Mercedes-Benz LIDW principle, because there'd been no change in Bahamian legislation, such as there was very, very recently in the BVI. The judge also said there's no jurisdiction to serve out in these instances. Now, I make no comment on the decision itself. I don't know a fraction of what I would need to know. But as propositions of law, those 2 points, I think, are somewhat doubtful. You can certainly obtain interim relief in support of an arbitration in the Bahamas, in the same as you can in the UK, under our 1996 Act, under the Bahamas 2009 Act. You can go to the court, you can go to the arbitrators in appropriate circumstances. You can't go to the court if you can go to the arbitrators, but sometimes it's not possible. They may not have been convened. None of that was doubted in the case, but the court said that for some reason that this was an injunction in aid of foreign proceedings, and I struggle with that. There might have been a good reason for it, but there's a troubling reference in the case to the place where the arbitrators are sitting, physically sitting, which jurisprudentially is utterly irrelevant in arbitration terms. It's got nothing to do with any of the factors. The court seemed to be ignoring the key issue of the seat of the arbitration. And this conflict of law element in arbitration is something trust lawyers are going to have to grapple with. Everybody knows, there are these two systems in arbitration. You've got your lex causa, either the law of the contract in a contract dispute or the law of the trust in a trust dispute. But critically, you've also got the law of the arbitration. And this is the sort of the curial law giving life and effect to the arbitration. It's, as Barry, above all others on this panel, would be able to testify to this, is the seat of the arbitration and the law that applies as a result is fundamental. So it's not some minor point, but it seems to have been treated as a minor point. The jurisdiction question is much simpler. The court said there was no jurisdiction to serve out. Well, there is. It was just apparently missed. In the amendments that Barry and Dancia have both mentioned in 2011, we introduced Section 79A of the Trustee Act, which you will all be perfectly familiar with. It follows the lines of the foreign elements provisions that have been applied in most of the offshore jurisdictions, which define the choice of law, the scope of the law, and also the jurisdiction of the court. And there is the usual cascade, whereby if the law of the trust is local, then there's local jurisdiction. If the trustee is local, there's local jurisdiction, and so The big problem in all of these arrangements, which go way back to the 80s with Cayman originally and Bermuda it's following on, and BVI in the early 2000s, they were all done with great respect by trust lawyers, not by litigators. So if they'd retained Charles and Dawn, then they wouldn't have made the mistake I'm going to explain in a second. And that is that there was no link between these statutory provisions and the rules of court. So you couldn't serve out as a result of these provisions. So we deliberately, in Section 79A sub 2, made provision for service out of the jurisdiction in every one of these instances. So you can serve out without permission in the Bahamas in pretty much any trust matter. And if you look at RSC Order 11, Rule 1, Sub 2, it basically says if there's a statute that gives the court jurisdiction in a situation where the person is out of the jurisdiction, then the court's got the jurisdiction. I don't know. There may be a good reason why it wasn't referred to. I can't say, but the court definitely has jurisdiction. With regard to enforcement, one of the big issues which was noted at the very, this whole exercise that we're all embarked upon sort of became quite popular towards the end of the noughties. And a number of us, I think several now speaking, commented at the time that the New York Convention might well be an issue because there is no agreement. Undeniably an issue. Enforcement will be complex. The first question is whether or not the New York Convention will or will not apply, simply because of the absence of a formal agreement. There is a lot of learning which indicates a very liberal construction of the convention, and there are a number of arguments which would say that there is sufficient of an agreement. It's possible also that the deeming provision that I think Barry explained earlier today, that's in, at least in the Bahamas statute, would have effect to constitute an agreement for these purposes. It depends on which law governs. You'll all be familiar with statutory deeming provisions being applied consequentially from start to finish. The uncertainty point is a problem in that regard, but there are lots of options here. You can sue on the award. You can, it depends on the jurisdiction, but you can sue in all common law jurisdictions at common law, and most have got statutory provisions. You can, in most jurisdictions, enforcement of foreign judgments provisions are extended not just to judgments, but they also include arbitral awards. And you can, failing that, you can convert your award to a judgment, and you just sue on the judgment. And last but not least, you can, to use an expression, you can sue on the contract. In other words, you could, in this case, obviously not a contract, but you can enforce the trust terms and the rights as found by the award, whether that's rights against a trustee, rights against somebody in wrongful possession of trust assets or whatever. You can sue on those terms, which will be effective within the law of the trust, because that's what the statute says. And in those circumstances, you should be pretty close to summary judgment territory, because there can't be very much to countermand what you are pursuing. So 90 miles an hour, I'm afraid, John, but I hope that's of some brief assistance.
No, David, that is extremely helpful. Thank you very much indeed. Sadly, our time has come to an end for this session of the LIDW. Judging by the vibrant discussion, trust arbitration is clearly a topic to be explored further. Whilst there may be a need for more case law to provide greater legal certainty with respect to mandatory arbitration, enforceability should be less of a concern where the parties have agreed to ADR contractually on an ad hoc basis for internal disputes. We've heard insights from some of the world's leading authorities in the field. As moderator, I would like to thank David Butler, Charles Lloyd, Dancia Penn, Barry Leon, and Dawn Goodman for their learned perspectives, in addition to David Bramble for having set the stage so eloquently at the end. I'm also grateful to the members of our audience for their participation I'd like to wish all of you a good weekend, and until the next time, thank you.